Hello friends, hope you people are doing fine. So now we are going to start one of the very important part of our Indian constitution, that is known as fundamental rights, which is contained in part 3. Fundamental right, it is one of the most significant provision of our constitution. Our framers had drafted and taken care of the importance ऑफ इंडिविजुअल राइट्स। ये अपने आप में एक बहुत ही बड़ी उपलब्धि थी इंडियन कॉन्स्टिट्यूशन में जब इसको फ्रेम किया गया। इफ़ वी सी वी कैन नॉट अंडरस्टैंड इस रियल इम्पोर्टेंस सिटिंग in the classroom and in the 21st century, but just imagine, can we ever thought of these kind of rights before? Why? What is the significance? Why it is so important? Let's discuss it. Why it is fundamental and why it is right? Here fundamental, why? Because they are so much basic and inherent to human existence in order to live a dignified life, that they are called fundamental rights, like right to equality, freedom of speech, life and liberty, because without them we cannot imagine a dignified and complete life. They are required for the full attainment of moral, physical, spiritual and intellectual completion. So therefore they are very fundamental, and here it is given as a right. A right, as we know, a legal right, which is here it is qualified with fundamental words. So it is a right towards the state, the authorities, that they will secure these rights and it cannot be abridged or abrogated in any normal circumstances, because this is a very basic right. Even in the judgment, Menka Gandhi judgment, Justice Bhagwati emphasized that these are the not a new right, but these are the basic rights which were available through our Vedic periods also. So we are in the habit of these kind of rights. India can boast this, but for the first time it was documented and given and guaranteed by the Constitution, and Supreme Court, as a guardian of the Constitution, has given this responsibility to enforce and ensure that these fundamental rights are implemented. तो हम यहाँ देखेंगे कि आखिर फंडामेंटल राइट्स इतना इम्पोर्टेंट क्यों हैं. कैन यू इमेजिन in ancient or in medieval period, can any individual has this kind of rights ever to claim against the lords or the kings? No. In medieval period we cannot imagine even to talk about our rights. The king is always right, the king can do no wrong, he has all the authority, all the might to enforce as per his whims and fancies. But these fundamental rights, a modern innovation which has curtailed the power of state and such authorities. Therefore their significance lies in curtailing the arbitrary authority. Here we will discuss and will see how they came into existence in the modern world. We'll trace its origin and its development, how it's developed. Then we'll see its significance and features. Okay, so let's see how it's got originated. First of all, in 1215 AD, in UK, some traders has threatened and uh, went to the King John, who was the incumbent at that time, to appeal for certain rights which are very essential in order to carry out their business. And for the first time in the history, such kind of document came in existence in 1215 AD. However, due to some reasons, it never got implemented in the way it was intended to. Then, during French Revolution in 1789, a charter came, a declaration of certain human rights against for the man and the citizen. The declaration. One of the important development in the course of the fundamental rights origin. Here they have guaranteed certain kind of rights to the citizen and the human being. But the most significant development came after the American Revolution, when it was ratified in 1791, when after the American Revolution, the most important right, the Bill of Rights, has got ratified in 1791. पहली बार इतिहास में ऐसा हुआ कि किसी कॉन्स्टिट्यूशन में इन फंडामेंटल राइट्स को एडॉप्ट किया गया, एसिमिलेट किया गया और गारंटीड किया गया. वो था अमेरिकन कॉन्स्टिट्यूशन बिल ऑफ राइट्स, एंड दिस फॉर्म द इम्पॉर्टेंट बेसिस for inclusion of fundamental rights in Indian Constitution. So we can definitely give thanks and thankful to American Revolution and their provision of Bill of Rights, which inspired our constitutional framers to adopt this fundamental rights. लेकिन इसके बावजूद हम एक कदम और आगे बढ़ते हैं अमेरिकन बिल ऑफ राइट्स से इस मामले में कि हमने बहुत डिटेल में सारे राइट्स को मेंशन किया और साथ ही साथ इस बात का ध्यान रखा कि वो पूरी तरह से एब्सोल्यूट ना हो, क्योंकि अमेरिकन कॉन्स्टिट्यूशन में दिस राइट्स वर गिवन द स्टेटस ऑफ एब्सोल्यूट ambit, but that was not the case with Indian fundamental rights. However, American Constitution of late has realized, and फिर वहाँ भी अमेंडमेंट हुआ और उन्होंने भी क्वालिफाई किया, कुछ लिमिटेशंस रखी अमेरिकन बिल ऑफ राइट्स पे. वो एक विषय था. तो हम यहाँ ये देख सकते हैं कि किस तरह से ओरिजिन हुआ और ये एग्जिस्टेंस में आया. फंडामेंटल राइट्स हमारे यहाँ कॉन्स्टिट्यूशन में आर्टिकल 12 से 35, दैट इज पार्ट 3 में डिस्कस होता है. अभी हम इसको वन बाय वन केटर करेंगे. अब हम सेकंड थिंग देखते हैं कि फंडामेंटल राइट्स में इनका नेचर क्या है, इनका सिग्निफिकेंस क्या, कुछ स्पेशल जो कैरेक्टरिस्टिक है उसको भी हम डिस्कस करते हैं. तो फंडामेंटल राइट्स को अगर हम देखेंगे तो ये पाएंगे कि दीज आर राइट्स अगेंस्ट द स्टेट, enforceable and enjoyed against the state. Why so? Because state, being the supreme authority, it's the responsibility of a state to ensure all the fundamental rights and secure for the well-being of individuals. तो फंडामेंटल राइट्स जो है वो प्राइमरली स्टेट के अगेंस्ट लाई करते हैं. जैसे कि मान लीजिए ये एक स्टेट है, मैं क्लास ले रहा हूँ, आई एम द अथॉरिटी और आप यू स्टूडेंट्स आर द सिटीजन ऑफ दिस अथॉरिटी, आई मीन दिस क्लासरूम. ओके, अब यहाँ पे मेरी अथॉरिटी मुझे मान लो है अनलिमिटेड अथॉरिटी है. मैं कहूँ कि भाई आप एक्स स्टूडेंट आप क्लास से बाहर जाओ विदाउट एनी रीजनेबल ग्राउंड. आपको बोलूँ कि आप उठ जाओ और वो आपकी जगह वो बैठ जाए. सो क्या क्लास प्रॉपर चल पाएगी? क्या जो मोरल है स्टूडेंट का वुड इट बी हाई? क्या वो जस्टिफाइड फील करेगा? क्या उसकी डिग्निटी कॉम्प्रोमाइज नहीं होगी? इन द सेम केस, if state would be given the absolute authority to treat any individual as per the whims and fancies of the occupant of the chair of the, I mean, prime minister or whoever the executive head, then it's going definitely to curtail and diminish the personality, the moral. So similarly, स्टेट को लिमिट करने के लिए, टू मेक हिम अकाउंटेबल एंड रिस्पॉन्सिबल. सो दीज राइट्स आर, हाउएवर देयर आर सम एक्सेप्शन. इट इज, देयर आर सर्टेन राइट्स which can be enforced against the individual also, like we'll discuss in detail how 15 to 17, 18, 19, 21, etc. Why so? Because these rights are so basic and important to an individual that even any private person cannot be allowed. Because if some private person is acting in public authority, or he is having say to discriminate you, then it is not possible to discriminate someone on unreasonable ground. So it is equally applicable to private also. How this evolved? When initially it was thought to be a vertical rights, but later on Supreme Court has adopted the doctrine of horizontal rights. How come? We'll discuss. Vertical rights. Vertical rights means that these rights would be applicable, would be enforceable against the state only, not against the private person. It was a narrower, limited and restricted view. But as our jurisprudence evolved, court has realized that as a welfare state has taken many kind of responsibilities, public-private partnership. The very nature of the government is getting complex. So there should be some mechanism to ensure the same responsibility against the private person also, if he is acting in such a way, but that is not reasonable. So similarly, against the private person also, these kind of rights can be made enforceable. One of the very famous and landmark judgment in Vishakha case, you must have heard of it in GS also. Vishakha judgment, that certain guidelines had been issued to stop or to control or to restrict the sexual harassment of women employed at the workplace. Later on, POSH Act has been passed by the government. But it is the seed, Vishakha guideline. So That was in that case only the concept of horizontal rights has been evolved. So here we can see that our judiciary is taking a very liberal and adoptive view that is very practical. क्योंकि हम ये देख रहे हैं कि इन मॉडर्न वर्ल्ड वी आर सीइंग कि प्राइवेट और पब्लिक अथॉरिटी मिलके काम कर रहे हैं. बहुत ऐसी जगह है, बहुत सारे ट्रिब्यूनल्स, बहुत सारे ऐसी क्वासी जुडिशियल बॉडी हैं यहाँ प्राइवेट पर्सनस भी इन्वॉल्व होते हैं. और बिकॉज दिस राइट्स आर सो फंडामेंटल that one cannot take waiver that I am a private person, so I am not amenable to this kind of rights. So no, everyone should follow and should take care of these responsibilities. So here we have seen key enforceable against the state. Okay. Another feature is that they give a concept of limited government. Why limited government? When if we see, in fact, a written constitution is already makes a government limited, and when fundamental rights have been already enumerated in that constitution, so definitely government have to be limit its authority. It cannot act in arbitrary way, because if state will try to abrogate any rights, lawful right of fundamental rights of any individual, then court must stop it. So a limited government, a responsible government, an accountable government is the result of these fundamental rights. It is also an antithesis to a draconian or authoritarian government. Draconian authoritarian government, what does it imply? अगर कोई गवर्नमेंट अथॉरिटेरियन है, इट मीन्स इज नॉट फॉलोइंग द रूल ऑफ लॉ, इज नॉट अबाइडिंग द बेसिक प्रिंसिपल्स of a natural justice, or he is not acting in a reasonable way. So for that purpose we can see that fundamental rights is act as an antithesis. It is antidote, a shield against the arbitrary government. So here we have seen various aspects of fundamental rights. We'll also see that there are certain exceptions that though they are very prime and very sacrosanct rights, but in case of emergency, when we'll see there are certain kind of situations where we cannot avail these fundamental rights, certain provisions have been given. So there are certain limitation and exceptions also as far their implementation is concerned. What are the limitation? Actually our framers has a very rightly felt that we have to negotiate between the individual rights and social needs, public order, morality. So any individual right cannot be so absolute, so large, unfettered that it ultimately it is going to harm the very purpose of the right, because absolute right will definitely going to compromise the other's right, as very famous statement of John Locke. Locke says that my liberty ends with my nose. Definitely if it will not end with my nose, then definitely it's going to hamper others' right. So in this way there are certain reasonable restrictions has been made that we'll discuss on the account of public morality, public order, sovereignty of government. If sovereignty of government is threatened, it is going to compromise, then definitely fundamental rights would have to face the uh, restrictions. So in that sense also, so there are certain limitations also. Now I'll see how the whole scheme of thing has been formulated in our constitution. So we'll see article 12 to 35. Article 12 says that unless the context otherwise expresses, the word state should include union government and parliament, state government and legislature, respective legislature of the state, any government or other authority existing in territory of India, any government or other authority regulated by Union of India. So here the definition of state has been given, four conditions have been given for to make them understand what is a state, because this word state is going to play a very crucial role when we will talk about the fundamental rights, because these fundamental rights are meant to be enforced against the state primarily, because state is the main litigant. So we'll see ki what is the state. Over the time, judiciary has also adopted and evolved this concept of state, and it had given a wide ramification of its meaning. We'll see the state is someone if it's include union government and parliament. So executive of central government along with the whole parliament, the legislature of union government, I mean at the central level. Similarly, all the state government and the state legislation. Then any government or any other authority. The word other authority is most debatable word, because it is not an exhaustive list. So where it's now up to the judiciary to decide whether such authority can be called other authority as per the constitutional scheme of thing or not. So various judgments have been evolved that we'll see ki, where government has, where Supreme Court has taken a stand that if some authority where government is having sufficient interest, the involvement is quite pervasive, it is regulated by government, whether state or central, then it will come under the definition of state. So like this way, Supreme Court has declared that LIC would come under the definition of state, BPCL, ONJC, where government is having a considerable stake, so it will come under the definitely the meaning state. Similarly, we will see that where that involvement is not so pervasive, like in case of BCCI, a very famous case, G Telefilms versus BCCI, NCRT, Ram Jawaya Kapoor. So here we'll see ki it has been discussed that BCCI and CRT will not come under the state definition. So, if we'll see ki in I mean, if in Nagarajan case, the Supreme Court has said that we have to give a widest possible meaning of the state and the fundamental rights, because as being a welfare state, the authority of government is very crucial, and it is very delicate and significant to hold a state responsible whenever such kind of rights got abridged. So, with over the period of time, we have seen the evolution of interpretative jurisprudence. We can say that Supreme Court has taken a very liberal journey and in interpretative jurisprudence, because in A.K. Gopalan case, the Supreme Court has taken a stand that all the fundamental rights are mutually exclusive. There is no organic unity between them. So, it was a limited view in Gopalan case. But when see in Menka Gandhi, in Minerva Mills, the court has evolved a very liberal interpretative jurisprudence and said that no, fundamental rights are not mutually exclusive, but they form a very coherent and organic unity. So, composite right concept has been evolved. Composite rights or organic unity, when we say, it means that Article 14 must be read with Article 19 and 21, as said in the Menka Gandhi case, in the Minerva Mill case, because without ensuring Article 14, how one will guarantee the Article 19 and 21? Without Article 21, how one can enjoy 14 and 19? So, we cannot see in isolation. Isolation is not possible. So, we have to see all the rights in a unity, a coherence. So, that was said by the court that there is a organic unity, and when we looking into the any infringement of the cases, any rights, then we have to consider all the fundamental rights in interconnected way. Okay, so